and welcome along to this video mini-series, Renters' Rights Bill, Landlords' Survival Guide. And throughout the series, we're going to be joined by industry experts discussing the Renters' Rights Bill and how landlords can plan for it, but also survive and thrive. And I'm joined, first of all, by solicitor David Smith. And David, on a scale of 1 to 10, how momentous are the changes that the Renters' Rights Bill represents?
It's a good question. I'd say they're probably like a 2 and a 10 simultaneously, in that obviously it's a different landscape, but for lots of landlords, a lot of the landscape won't matter that much. Because in practice, most landlords get their rent paid, the tenants leave, they don't destroy the property, they get it back, they move on. But then for a subset of landlords who are either doing something they shouldn't be doing, they'll have a big problem. Landlords who are running slightly more unusual business models, it will be more complicated and more substantial.
And which countries of the UK does the Renters' Rights Bill apply to?
It's England only, because housing is a devolved competency, so Wales and Scotland and Northern Ireland all do their own things. There are, in fact, though, bits in the Renters' Rights Bill which do apply to Wales and Scotland, but by agreement. So one thing the Renters' Rights Bill does is introduce provisions about discriminating against tenants with children and tenants who are on benefits. Those provisions are being cross-decked into Scotland and Wales as well, because the Welsh and Scottish governments asked for that to be done.
Okay, so obviously the abolition of Section 21 grabbed all the headlines from even when it was previously the Renters' Reform Bill that the Conservatives attempted to bring in. But that's obviously one of the very key changes which has concerned landlords. What would you say are the top 3 key changes that landlords must be aware of?
Yeah, I mean, the difficulty is people get very excited about Section 21, but again, if you look at the figures, most landlords never serve a Section 21, or if they do, the tenants just leave. I think it's more interesting is the removal of all fixed terms. That's actually more momentous in some ways, so all tenancies are periodic all of the time. And that, of course, means that tenants can leave quite early in the tenancy, or can stay there for a very long period of time. The requirement to have a written tenancy agreement with specific wording in it. We don't know what that wording is yet, but that's going to affect a lot of landlords because they're going to have to change all their tenancy agreements. So there's a practical change there. And I think rents, the way that rents are to be handled going forward is much more complicated. It's quite different. And that's likely to be more relevant as tenancies are on a rolling basis and landlords want to increase rent from time to time. To
uninformed landlords, there are, very significant threats, aren't there?
Yeah, there could be, depending on the circumstances. In terms of if you're uninformed or ignorant, there's quite a lot of offences associated with this. So, for example, if you're not aware of the legislation and you try and get a tenant to sign a new fixed-term tenancy, that is in itself an offence. If there is if you require a tenant to, or you give a tenant a tenancy agreement that doesn't conform with the new requirements, that's an offence. And both of those things also can attract a civil penalty from a local authority, which is more like prosecution. And further, in some cases, you can also get a rent repayment order made against you for up to 2 years. So the rent repayment orders are increased from 12 months to 2 years. And so I think the biggest scare, as it were, is about this is that all of those landlords who are watching videos like this have no idea about any of this stuff. And there's a huge number of properties that are let by people who have absolutely, I see it to landlords who are blissfully unaware of the existence of tenancy deposit protection. And that's been around since 2007. So, it's the landlords who are blissfully unaware of what's being discussed that I think are the ones who are really going to get badly hurt.
And ignorance is never an excuse in a court of law.
It's a very limited defence, for sure.
And there are even some criminal sanctions, aren't there?
Yeah, I mean, you can be prosecuted for demanding a fixed-term tenancy. In practice, I think local authorities will tend to civil penalty people, and the penalty maxes at £7,000 for a first offence. But yeah, people think you've done it deliberately and knowingly to procure an advantage, then you can expect to be prosecuted. So in principle, you could be fined an unlimited amount of money.
Well, that's why this video series is so important.
That is true. That's why people should watch these videos.
This series is powered by Title Guardian, and actually using their tools can actually help mitigate some of the risks of the Renters' Rights Bill. Could you just talk a little bit about that?
Yeah, so one of the things that's quite problematic for landlords classically is people renting their property and then subletting it, and then particularly subletting it as an HMO or something that requires a license. And of course, they're already cheating a bit. The chance of them getting an HMO license is quite poor. And you're getting caught out by that. Up till now, you could be prosecuted for that or civil penalty by a local authority. They tended not to, but they may well do going forward. But you couldn't have a rent repayment order against you because the Supreme Court said in Rackison and Jepson you couldn't. But that's going to change. You will be able to have a rent repayment order sought against you, and it will be up to you to show that you either didn't know and couldn't reasonably have known. And that's quite difficult to show. So, of course, the best way is to make sure that you do know, and then you can take steps to deal with it. And products like Title Guardian are good or helpful in terms of identifying uses of your property that you weren't expecting and alerting you to situations. So, and again, you can use that as part of your defence. So if you say, well, I actually have this product that is supposed to alert me to a range of scenarios, but they managed to evade even that, then, what else could I have done? I've made an effort to find out what's going on with my property, and I didn't know. And so this is why I have a defence to a rent repayment order.
Because it also notifies the landlord if the property is used as a registered business address.
Yeah.
Why would that be important for a landlord to know?
Well, that's just more important in general now because there's two possibilities. Someone might register an address on their business address there because they're Airbnb-ing it or using it for short letting in some way. But increasingly also VAT fraud comes up in these situations, and this is a common VAT fraud structure, and there's been a lot of discussion recently about the fact that companies' houses just registers addresses for companies left, right and centre without any particular check or investigation being done. And so it's generally a good idea to make sure that people aren't registering your address, even if it's your own home. And there are some very unlucky people who have found their own home address registered for like 20,000 companies, all of which have engaged in some form of VAT fraud, and they're getting letters through HMRC, like hundreds of them, demanding VAT, and they've then got to show that this company has nothing to do with them, and so on. It's quite difficult.
So how can landlords plan for the Renters' Rights Bill? I mean, I think the obvious first thing is to get informed and then stay informed, because we're speaking in mid-November and it's still going through Parliament and it may be tweaked a little bit along the way. So what can landlords do to start planning?
They need to look at the type of business they're operating, look at what the Renters Reform Bill is going to do, consider whether that's going to affect their business. But then I think you would look at the classical things. Is the tenant that you have now one you want to stick with for longer term? Because once the Renters Reform Bill is in, they are potentially your longer term tenant, and you should consider that appropriately. Obviously, you should bear in mind that just throwing out your current tenant doesn't necessarily mean the next tenant will be better, and so sometimes sticking with the devil you know is the way to go. You should look at your rent levels. It will be more difficult to increase rents, so you should be bringing your rent up to a market level before the bill comes into effect. And you should just stay alert, because you are going to have to join a PRS database and a redress scheme, and you are going to have to deal with your new tenancy agreement. So you should plan for that admin load that you're going to have to do, and obviously make sure you can pay for it.
And there will be a transition period, presumably.
I assume so. The government hasn't said there is one, but I'd be very surprised if they just turned around and said, oh, by the way, you're all now breaking the law. That would be an extremely perverse thing to do. So yes, there will be some form of transition period, but it might be quite short. Right.
So we're waiting for the commencement date, which is when the new periodic assured tenancy agreement has to come into play.
Yeah, and an important point to bear in mind is that it affects not just new tenancies, but actually existing tenancies. So one of the big things about the Renters' Rights Bill that people aren't fully understanding is that existing tenancies lose their Section 21 ability instantly as soon as the Renters' Rights Bill comes into effect. Existing fixed-term tenancies cease to be fixed-term tenancies and become periodic tenancies on a fully assured basis instantly. So that's why I say your current tenant, maybe your long-term tenant, Because if you let them ride through into the new regime, then they will effectively get a periodic assured tenancy, and it will be as if they had always had one. So there is an aspect to which you want to consider what you have and whether it's the right arrangement for you.
I can envisage chaos.
Yeah, and some landlords are selling up left, right and centre, but this is why I always want to be cautious about it. So quite a lot of people are saying, oh, all landlords should sell, but that's not true. I mean, the reality of the situation is that there's still a shortage of properties. So the supply and demand equation remains on landlord's side. There are more tenants in most areas than there are properties available to them. And so the rental market remains a buoyant market, and that's not going to change. So that's not to say there are other investments. And, if you're taking your free choice today, you may not invest in this market, but you might. But that doesn't mean that you should sell up now, throw it all out and give up and move into another investment which might be equally perilous, simply because you've read on a forum somewhere or someone said to you on a camera that it's all a disaster, because it's not all a disaster. It's a different challenge, but surviving business challenges is what makes good businesses.
Quite. Well, I agree 100%. Could you clarify the position on rent in advance? Because there has been some confusion about that.
I mean, in practice, no, I can't clarify it because no one knows what the position is. The government has written a bill that seems to suggest you can't have rent in advance. The government says that's not what they've done, but they're not very clear about why they haven't done that. What they now appear to be suggesting is that although they've said you can only have a charge rent on a monthly basis, there's nothing that stops you asking for several of those months before you agree to sign a tenancy agreement. But this position is not finished. An amendment was put down in committee and rejected by the government that would have actually said you could only take a month's rent, full stop. That amendment has already been tabled to come back. The government has also been clear that they are a bit worried about rent in advance because they see it as exclusionary and reducing accessibility for some people in the sector, and they're not huge fans of it. So they have said that they are open potentially to banning rent in advance. So the answer is,
Watch this
quite
space.
Sure yet.
Watch this space.
But there are obvious problems. I mean, particularly in the overseas student market, rent in advance is particularly important. But then for those specialist markets, I think you'll find that people will adjust their operating model and actually potentially do something else that takes them outside the general scope of the Renters' Rights Bill. And that's not entirely a bad thing. One of the odd things that might come out of this is that you'll actually see particular market sectors operating in particular operating models that are kind of unique to them, and obviously that's more interesting for me as a lawyer, but it also in a sense is in some ways better, because one of the problems we've always had is this idea that you try and shoehorn the whole private rented sector into one AST based structure, and that's what we've done to date. As you break that up, you potentially have a series of different models that may not be perfect, but may work quite well for that market sector and represent a reasonable accommodation between landlords and tenants as to what they're prepared to accept and desire.
Okay. So we've mentioned the new assured periodic tenancy. I presume that's being drafted now, and landlords will be able to download it from the government website and other industry stakeholders like the NRLA, presumably.
Well, it's not being drafted because no one knows what's going to be in it.
Oh, right, okay.
So what the government has said is that they are intending to have regulations which will specify things that must be in such a tenancy, but nobody knows for sure whether that's going to be like Wales, where it's very highly specified and where there is in fact a model agreement, which most people do tend to use some version of, or whether it's going to be quite lightly specified, and there may well or may not be a model agreement, but which almost nobody uses. Nobody really uses the model agreement in England because it's not very good. So there is quite a bit of pressure on government to be clearer about what it is that they're going to ask for, but they've not said much about it yet. But yeah, as soon as people do know what these things will look like, people will start trying to meet that requirement, because and this is one of the funny things about this situation, is that there's not actually that many people who draft tenancy agreements. I know people get tenancy agreements with lots of different places, but actually you're only looking at the work of 5 or 6 individuals in practice.
You're one of them.
I've written a fair few, but you're not looking at that many people to generate this stuff. So one of the odd things about it is that actually, people say, "Oh, we'll change all tenancy agreements. How hard could it be? There's lawyers everywhere." But actually, most lawyers are collapsing back onto a very small number of suppliers.
Well, let's talk about pets quickly. There's provisions about tenants being allowed to own pets as a default position. What should landlords sort of take into account and do to protect themselves from pet damage?
Right, so the position is that you can still advertise properties as no pets, but once a tenant has moved in, unless you have a superior lease clause that says no pets, it's difficult for you to say no to pets without a reasonable cause, and that will be up to the court to decide what a reasonable ground or cause is, but it will be hard for landlords to say no to pets, and that is intentional. The objective is that tenants should be allowed to have pets. What's really unclear about this is what the actual demand is. Some pet advocacy groups say the demand is huge, because what they've done is said to tenants, if you could have a pet, would you have one? And with that kind of open question, the answer is frequently, well, yeah, if I could. But it's not a very practical question, because the reality is that they might be told, well, you can have a pet, but they might still say, well, I've still got to go to work every day, so of course I don't want a pet. Or actually, the person I live with is allergic to pets, so I don't want to have a pet. So it's not a terribly accurate set of survey data, and we just don't know whether there's going to be some epidemic of tenants turning around and saying, yes, I want 500 micro pigs. And then the other problem, of course, is there is going to be a suitability point. It's obviously going to be reasonable to say to someone who wants to put a Great Dane into a 1-bed studio flat, I don't think this animal is remotely reasonable. And I always tell this joke about the movie The Commitments, where there's this great scene in Dublin where this guy goes into a block of flats and there's a kid trying to load a horse into the lift. And he goes, why are you taking this horse into the lift? And the kid goes, well, he can't walk up the stairs. And the guy's like, okay, fair enough. And but there's this problem, is that some people will have animals that are just deeply inappropriate. And of course, opinions will also differ. Some people will say, well, all flats are unsuitable for pets. Other people will say, well, no, they're not, because some cats don't particularly want to go outside that much. They're house cats. So there's a diversity of opinion about what constitutes a suitable pet. And these are all problems that the courts will have to resolve. But ultimately, from a landlord's perspective, you will be able to obtain insurance in principle, provided the market produces such policies, and you can ask the tenants to pay the cost of that insurance. And that will be the landlord's protective function, so against any additional pet damage. I mean, again, though, this is one of those situations where it's just a little bit overblown. You know, of course there are horror stories of people who have got tenants who had pets who then destroyed the house, but that's not really a pet issue, that's a tenant issue. There are plenty of landlords whose tenants have pets, and it's fine.
Okay. Well, as we wind up this first instalment, David, what are your tips for surviving the Renters' Rights Bill? And should landlords keep much more detailed records and audit trails going forwards from now on, really?
Well, I'll answer your second question first. I've always thought landlords should have more detailed records and audit trails, and I've always thought that. But yes, it will be important under the Renters' Rights Bill, to even more important to do that and to have things in writing. What should landlords do? Don't panic. It's always a good start. Actually go and do some research and work out but carefully, because there's a lot of misinformation, but work out what the bill is actually going to do. Consider whether it really affects you, and then what you might choose to do to mitigate those effects, if you need to, and there'll be plenty of others who don't. And then just stay aware and alert, because things will happen quite quickly, probably, as we move through 2025.
Well, one thing that landlords might like to do is move to a fully managed service with a reputable letting agent, and we will be speaking to a letting agent later in the video series. So thank you very much, David. We'll see David again in another video later on, but for now I just want to let you know that we do have a downloadable ebook also titled The Renters' Rights Bill Landlords Survival Guide, and I do invite you to download it. You'll find the link below this video, and please stay tuned as our video series continues.